Okay. So CPC, what is it all about? What things are mentioned there? In short, if you have to say, what is CPC all about?
CPC is on acts which we need in our law.
Yeah. So what provisions do we get there? CPC, as the name itself suggests, right? What is it? It is talking about procedures. Okay, so CPC talks about procedures. Now, what kind of procedures? It talks about civil procedures. Okay, so if there is a civil suit that I want to file in the court, what procedure I need to follow, what process I need to follow, that is laid down there, right? Which court I should be approaching, how I should be approaching the court, how I will let the court know about my matter, what all different steps will be there, how I will submit my evidences, how documents will be presented before court, how witnesses can be called, how court will give me some notices. All of that is mentioned under CPC. Okay, so that's nothing but procedures to be followed in a civil suit. Okay, so first of all, we need to understand uh, the classification of laws, which is substantive and procedural law. We will see that part also. Okay, so when we talk about CPC, civil procedural law, it consists of the rules and standards which courts would follow while conducting civil trials. If I file a civil suit, court will have to give a decision. Before giving the decision, whatever processes, whatever steps are there, everything is mentioned under CPC. These rules govern how a civil suit will start, what are the different steps will be followed, and finally how the case will be decided. All of that is mentioned there. Civil actions concerned with judicial resolution of claims by private individuals or groups, companies, organizations against another, and in addition, governments or subdivisions or agencies may be parties to a civil suit. When we talk about civil suits, it may be a dispute between two persons. It may be a dispute between you and me. It may be a dispute between one person and an institution. Maybe you versus KSLU. It may be you versus the government. It might be a lot of different parties, who different people or groups who can be parties to civil suits. And what process will be followed? That is mentioned under CPC. Okay, when we talk about CPC, there is like this basic classification that we need to know. It is classification of law. When we talk about laws or different legislations or different acts, right, that are there, like Indian Penal Code, Contract Act, Constitution, CPC, CRPC, so many legislations are there. All these legislations can be classified in two groups. Okay, all these legislations can broadly classified in two groups, that is substantive and procedural. Okay, so what is the difference between substantive and procedural? Have you heard these words before?
Yes, ma'am.
So what is the difference between them? Are you aware what is substantive and procedural law?
No, ma'am.
No, okay. So, as the name itself again suggests, procedural law, as in it tells about the process. Okay, and substantive, as in it's providing for substance, it's providing for the content. Okay, so substantive law, when we talk about it, it establishes rights, duties, and liabilities. Okay, so substantive law is those legislations, those statutes, those acts which are talking about our rights, obligations, liabilities. Like if you take the example of IPC, Indian Penal Code, it provides for list of different crimes that may be committed in India, plus the punishment for it. So IPC will be a substantive law. Same ways, Indian Contract Act tells us about our rights and obligations when we enter into a contract. It's a substantive law. Then Income Tax Act, it tells that we have an obligation to pay income tax. It's a substantive law. Okay, so it is telling us about our rights, obligations, different types of crimes, their punishments. Or in case of civil suits, different types of remedies that we have. When we talk about procedural law, it tells about the process. Fine, you had a right, your right was violated. Now what? Which court you would be going? What kind of a case you will file? How you will file the case? What will be the steps involved? That's explained in procedural law. So when we read IPC, we know that murder is a crime. But what if murder has actually happened? What do we need to do? How we need to proceed? That's explained in procedural law. If there's a contract between you and me, I have an obligation to fulfill the contract. If I do not fulfill the contract, what will happen? You can approach the court and file a case.
Okay.
How you will do it? That is explained in procedural law. You need to follow process of CPC. Right? So substantive law tells us about rights, duties, obligations, liabilities. Procedural law tells us about the process that we will need to follow once we approach the court. So substantive law consists of written statutory rules which are passed by legislature that govern how people behave, and it also defines our rights and responsibilities as a citizen. That as a citizen, I should not kill another person, I should not cause harm to another person. If I have entered into a contract, I should not violate that contract. Like that, it tells us how we should behave in a society. But procedural law gives us an idea on which court we should be approaching for what matters, what are the different steps that will be followed, what sort of a relief we can ask from the court, all that we get from procedural laws. So substantive law determines the facts which constitute a crime. That if we kill another person, that is murder. If we take somebody else's property, that is theft. Like that, it tells that if you do this certain thing, it is called as this crime. That is given under procedural law. But substantive law and procedural law helps us in deciding which court is the right court, where we should approach for what kind of matter, so we get an idea for that. Substantive law relates to matters outside the court because these crimes, they take place outside the court, right? But when we talk about procedural law, it deals with matters inside the court. Inside the court, what process is to be followed? If I want to present some documents before the court, how I will do that? All the process or procedure is explained there. Some examples would be Indian Contract Act, Indian Penal Code, Income Tax Act, Karnataka Police Act. All these are substantive laws. But CPC, CRPC, Indian Evidence Act, which tells us how evidences can be presented before court, Limitation Act, Court Fees Act, Suits Valuation Act, all these are examples of procedural laws. Okay. Is it clear the difference?
Yes, ma'am.
Any point if you find confusing, you can ask me, okay?
Okay.
Now, when we talk about CPC, if you look at the BEAR Act, it's a very, like, you can say broad legislation, okay? Code of Civil Procedure. You will see a lot of different procedures, a lot of different things are mentioned there. Okay, so it's like 301 pages. Too many provisions, too many procedures are there. But what is it all about? When we talk about CPC, it contains mainly two different parts. Okay, two different things are there. First of all, there are lot many sections. There are total 158 sections. Okay, so if you see, these are the sections we have. 158 sections which are divided in different parts. So if we look at IPC, we have 12 parts, and in 12 parts we have 158 sections. So each part will deal with one matter. Like part 1 deals with suits. If you look at part 2, it deals with execution. Like that, one part would deal with one specific area. And in that specific area, we have many sections providing further details. So first of all, we have 12 different parts and 158 sections, which lays down general principles relating to power of court. It just tells us that this is what court can do. This is what court can do. That is what court can do. It just tells us in brief what powers are given to the court. But as I mentioned, it is a procedural law. It lays down the process in detail. It's not enough simply stating that this is power of court. It has to also explain how that power can be exercised. And that's the reason why we also have one schedule in CPC. Okay, schedule is nothing but like an extra information that is given. So we have one schedule. Within that, we have 51 orders. Orders are nothing but it mentions the procedures, methods, and manner in which jurisdiction of court may be exercised. If it says that, okay, this is how you can approach the court and you can file a case. In detail, in orders, you will get that you need to give this information, you need to give that information, you need to narrate the story, all of that would be given. So sections in general, in brief, tells this is a power of court, but orders in detail tells us what we should do, how we should approach. Everything is given in detail. Okay, so we have 51 orders which are given in one single schedule. And we have 158 sections which are divided into 12 parts under CPC.
Okay.
Okay, so this is what the entire legislation looks like. 158. See, 158 sections are there. After that, we have schedule. So earlier we had 5 schedules, but now these schedules are repealed. These are not applicable. So we just have one schedule which provides for all the different orders that we get. Rules of procedure. Okay, apart from that, we have appendix also, which like gives us some forms also, how we should approach the court, that is mentioned there. Okay, so CPC, when we talk about it, it is having 2 parts. First of all, body of the code, which tells about powers of the court. And then we have schedule, which provides in detail how we need to approach the court, what will be done. So earlier there were 5 schedules, but now schedule 2, 3, 4, and 5 are repealed. They are not applicable. We just have one schedule, which is having 51 orders, and each order contains multiple rules that vary in number from order to order. Some might contain 20, 30, 50 rules also. Some might contain 1 or 2 rules also. Plus, along with that, we have some forms also. How plaint will be submitted, how written statement will be submitted. For that, we have a form. Process formats we have, discovery, inspection, admission forms we have, decrease, execution. For that, we have like a template sort of a forms we have, which can be used by practicing advocates for convenience that is being provided. Okay, even though we say that, okay, CPC is there, all these rules, regulations we need to follow, some slight modifications high courts can make. Okay, high courts can make slight modifications in terms of rules and regulations. That might be this is going to be more convenient, more, like time saving for parties. So high court can frame some rules which should be applicable in the lower courts while filing the procedures. Okay, so when you look at the syllabus, first we have distinction between procedural law and substantive law, where we have that table. Then we have history of the code, its extent and its applicability. That part we have, and after that, suits start. History of the code, that is how CPC came into existence, what is its history. Okay, to give uniformity to civil procedure, Legislative Council of India enacted Code of Civil Procedure 1858, which received assent of Governor General on 23rd of March 1859. The code, however, was not applicable to the Supreme Court in the presidency towns and to the presidency small causes code. So to few courts only it was applicable. Whatever rules and regulations were framed in this first code, which was formed in order to provide uniform regulations for civil matters. It did not meet the challenges and was repealed by the Code of Civil Procedure 1877. but still it did not fulfill the requirements of time and large amendments were introduced. In 1882, the Code of Civil Procedure 1882 was introduced. With passing of time, it is felt that it's needed flexibility for timeless and uh, timeliness and effectiveness. So a lot of procedures, a lot of formalities, if we have, it's going to like be a lot more time taking process. So in order to simplify that, it was realized that we needed flexibility also in some matters. And to meet all these problems which we have seen, the Code of Civil Procedure 1908 was enacted. Though it has been amended number of times, it also stood the test of time. Even till now, we are following it. Even though we have seen amendments being made, changes being made, this legislation is being applicable. So before 1859, there was no uniform codified law relating to the process or procedures which will be filed by followed by civil courts in India. And in those days, the crown courts at presidency towns and provincial courts at mufassils were governed by different systems of civil procedure. So rules and regulations were not uniform. It used to vary from places to places, from courts to courts. There was no uniformity as such. So for the first time in 1859, uniform civil code procedures were introduced with passing of CPC 1859. But it did not serve the purpose because it was not applicable to many courts. So it was again not uniform. We had differences in terms of the procedures which were followed. After passing of Indian High Courts Act 1861, the Supreme Court and Sardar Adalats were abolished. In their place, High Courts were established in places like Madras, Bombay, Calcutta. And Code of 1859 was made applicable to High Courts as well, and these other courts were abolished. The Code of 1859 was amended from time to time and was repealed with the passing of Code of 1877. 1877 Code was also amended 2 times, and in 1882 the third Code of Civil Procedure was enacted. And this code was amended several times again in order to make the required changes, and finally all these defects were cured by way of 1882 legislation. Okay, so in order to bring this uniformity, a lot of changes, a lot of amendments we have seen in the existing legislations also, and finally this 1908 code is there, wherein also lot many amendments are there, but still this is working well at present time also. Even the high courts are given the power that you can frame some rules and regulations in order to make the process more smoother and more effective in your respective state, but still majorly these provisions is what we see are being followed. Okay, now when we talk about this legislation, right, its extent as in where is it applicable? Okay, so the Code of Civil Procedure is passed in 1908 and it came into force on 1st of January 1909. As in from this particular date, it became applicable. Whatever civil process cases were there, this code would become applicable. These processes need to be followed. So this code extends to the whole of India except the state of Nagaland and tribal areas, provided that the state government concerned may, by notification in official gazette, extend the provisions of this code or any of them to the whole of the state of Nagaland or to such tribal areas as it may think fit. So when we talk about Nagaland, they are governed by their customary Naga code, customary rules and regulations. But even after that, if government feels that certain parts, certain provisions can be added, can be made applicable, government is given that freedom also. So under constitution, they are given some special powers and status in order to protect rights of the tribal people. So there it's not applicable. They have their own Naga code which is applicable there. Okay, so this is the extent that it's otherwise applicable to the whole of India. Okay, when we talk about scope of this legislation, to what all matters it applies and what is its scope. So this is an exhaustive code and it deals with matters related to the civil procedures. However, it is not exhaustive on points not specifically dealt here with. It is incapable of contemplating all the possible circumstances which might arise in future litigations. Now, when we talk about the procedure that is being mentioned, procedure that is being followed in a civil suit, this legislation is framed or this legislation is drafted thinking about what might be the situations. Right, so this legislation is framed thinking that okay, how parties will approach the court, which court they will approach, how they will file the plaint, all of that they have framed. But yes, there are certain matters which might come in the future which are not covered in this legislation. Like if you talk about last 2 years back during COVID, what happened is courts started to function online. Previously, there was no provision, right? That online court hearings would happen and all of that. There was no provision. So, as such, we can say that CPC is not including those provisions, how online hearings will happen. But at that point in time, because it was need of the hour, Supreme Court took up the matter and Supreme Court gave powers to high courts that what you do is for your specific states, you see what rules and regulations need to be framed and you make sure that online hearing of cases become possible. And all the different high courts pass different rules and regulations. Some of them said that okay, we need to have this much of internet speed, this like audio visual facility should be there in the court, they should use this certain mode, maybe Zoom, Google Meets. All that rules and regulations were framed by high courts and that became applicable. So when we talk about CPC, a lot of matters are there which it deals with. It exhaustively deals with those matters, but there are certain matters which comes in the future that is not covered. So there we can frame these sort of rules and regulations and deal with the day-to-day functioning of the court as well. Okay, is this part clear?
Yes, ma'am.
So this code specifically provides that nothing in this code shall be deemed to limit or otherwise affect the inherent powers of the court to make such order as may be necessary for ends of justice. So during COVID, it was thought that, okay, if we are keeping the cases pending, that is not going to provide justice to parties. But what we need to do is, anyhow, we need to hear cases because we do not know when situations are going to be normal. So what we can do is we can rather shift to online hearing mode. So like that, whatever is needed, that is given to the courts. Okay, inherent powers of the court, it is not going to affect that. Courts are having that power, like High Court, Supreme Court is having that power. The code is the general law. It does not affect local or specific laws in force. In event of conflict between the code and a special law would prevail. However, the provisions of the code would prevail if the local law is or special law is silent. So if some other rules, regulations, provisions are there, those are not like, those would not like become void. Those might also become applicable if that can be proved by the parties before. Okay, so we have difference between substantive, procedural, history of the code, its extent and its application is there. Okay, after that we have jurisdiction of the courts. Okay, what are different types of jurisdiction, what all matters court can entertain, that part we have. So we'll continue with that part tomorrow then.
Yeah, ma'am.